TV admission, item 1.
Yes.
Yes, may please a lot.
As per this Honorable Court's order dated 28/7/2026, the state respondents PWD and P&E has filed their affidavit yesterday. It may not be on report yet, my lord.
You filed it today?
Yesterday evening.
Okay. Ms. Linda, additional AG for the state of Mizoram, representing
The respondent 1 to 4.
1, 2,
1, 2, 3, 4,
1, 2, 3, 4,
7, and 8.
7 and 8 submits that the affidavit on behalf of the respondents have been filed yesterday. Stop. The said affidavits are not available on the case records. Registry will trace out the affidavits and connect it to the case record and list the matter.
Can I ask for can we have on target on 2nd September
2nd September.
and for respondent 5 to 6?
Be listed again on 2nd September.
That's what makes lordship.
Oblige, my lord.
That one?
I seek your lordship's indulgence in making a mention regarding item number 12 of part 2.
1 minute, 1 minute. I need to have my cause list. Cause list. Cause list. Item number 12,
12 of part 2.
part 2. Okay. What is your prayer?
My lord, as agreed to by all the parties, my lord, if this matter may come up on 25th 8 2026, next
25th,
Tuesday,
8.
25th, yes.
Item number 12. You either have it on Tuesday,
Tuesday.
25th.
Yes, lordship.
All right, 25th, item number 12. Please call up. Huh? 25th.
Obliged.
Yes.
May I seek your lordship's indulgence in mentioning one unlisted item, that is WPC 20 of 2024. Lordship, may this matter kindly be taken up tomorrow?
Tomorrow.
Yes, my lord.
Tomorrow is not unlisted, it will come as a listed item. If it is unlisted, I thought you wanted it today.
No, we wanted it for tomorrow, and the list for tomorrow is already out. So
All right, all right.
may this matter be
Be listed tomorrow.
okay. Much obliged.
Yes.
My lord, if I may, item number 17, part 2.
Part 2.
Yes. I have spoken with the learned senior counsel for the respondent. If this matter may kindly be taken up tomorrow.
Tomorrow. All right.
If
Tomorrow.
obliged.
May it please your lordship, may I seek indulgence in mentioning item number 8 of part 2, with the consent of other parties, if the matter may kindly be taken up after 3 weeks, if possible, your lordship.
Item 8.
Yes, your lordship.
8 is connected with 6 and 7. 5, 6 and 7.
Yes, your lordship, I have taken consent of
From
other
all the
parties.
council.
Yes, your lordship.
Item MS, your name?
Miss Lariam Rotteringly.
MS so-and-so appearing for the petitioner.
Yes,
Appellant.
your lordship.
In item number 8 submits that on due consent that this matter be listed after 3 weeks. Item 8 is connected with criminal appeal so-and-so is connected with item 5, 6, 7. Therefore, it is submitted that consent of all the councils have been obtained. Item 5, 6, 7 be listed again after 3 weeks.
Deeply obliged.
Daily list for motion, item number 1.
May I please the lordship, lordship, this writ petition pertains to the withholding of the whole compensated amount as already assessed by the competent authority. Lordship, the petitioner have a landed property bearing LSC number 3 of 2019.
For today only notice,
Yes, your lordship.
right, heard learned counsel for the petitioner. Anyone for the respondent?
Number 2 and 3.
MS so-and-so appears for respondent 2 and 3. I am for respondent number 1. MS so-and-so, learned CGC for respondent number 1. Notice be issued, returnable 3 weeks. Since the respondents 1, 2 and 3 are represented by the respective counsel, notices are waived, however, extra copies be furnished within a period of 1 week from today. I think you can appear for number 4 also.
Number 4.
Kala?
4 is the Kala, your lordship. We do not appear for the Kala.
Kala is the district commissioner.
No, lordship, it's an autonomous body and
right, all
the
right.
state government does not appear.
Notice on steps on respondent number 4, 5, 6 by speed post within 3 working days. Matter be listed again immediately after the returnable date. Is there any interim prayer?
No, your lordship.
All right.
Deeply obliged.
Item number 2.
Lord, in this case, we challenged a revision of award made with respect to the petitioner's compensation that was awarded to them by draft award number 1 of 2025, my lord. And this draft award number 1 of 2025 was approved by the competent authority. And after it was approved by the competent authority, my lord, some corrigendum was made And by this corrigendum, their amount of compensation that was assessed was significantly reduced, my lord. And so because of this reason, my
This
lord,
is under the National Highway Authority Act,
my lord, this is under the
Land Acquisition.
Land Acquisition Act of
Land
2000.
Acquisition Act. The compensation has been released in part or no compensation at all?
It has been released in part, my lord.
In part.
Yes. The
I
corrected
think
amount.
there's a provision for filing an appeal before the competent authority there.
So,
If you are aggrieved by the amount of
my
compensation
lord,
released,
what we are challenging, my lord, is,
new one. Yes.
my lord, we are challenging the validity of that new one itself, my lord. Because, my lord, the very question of appeal would not arise, my lord, if the jurisdiction to make that amendment itself does not arise, my lord. That's basically our submission, my lord. Because if your lordship will see section 33,
We are yet to find a copy of the book. If you have an extra copy, you can give it to us.
I'm sorry, my lord, I did not bring the extra copy.
You're referring to the new act.
To the new act, 2013, my lord. In section 33, it said,
All right, we'll get a copy from the library. Just we'll call it up after a while.
certainly, my lord.
Courtmaster, please ask for a new copy of from the library. Good. We'll call it up after a while.
Item number 3.
Yes.
May it please your lordship. Lordship, I appear for the petitioner who is the widow of late Fulannath, lordship. So, lordship, the petitioner's husband has been working is a government employee who is working under the powerlifting department for nearly 34 years, lordship.
The pension, you were asking for
Just
pension.
their pension and the death gratuity, all the benefits, lordship.
Right, heard counsel with the petitioner. Issue notice returnable 3 weeks. You're appearing for the respondents?
Yes, Your Lordship. 1
All?
to 6 state respondents.
MS so you're the government counsel?
Yes, Your Lordship.
Then a government advocate appears for all the respondents.
Yes, Your Lordship.
Therefore, notices are waived, extra copies will be furnished within a period of 1 week. Claim of the petitioner is for release of family pension, death gratuity, leave encashment, etc. in respect of the services rendered by her husband. Although her late husband expired in, when did he expire?
10th of November 2025, lordship.
10 November 2025. The dues in respect of the services rendered has not been released to the writ petitioner, who is the widow of late so-and-so, the employee. Let the respondents complete their instructions and file necessary affidavit. If so advised, in the meantime, matter be listed on after the returnable date. You want a fixed date?
No, lordship, any day, when the matter may come up in due course, lordship.
Due course. Which is a pension matter, we'll give you a fixed date, 18th.
2nd of September, lordship.
Second will not be 3 weeks.
Okay.
11th,
11, lordship, yes.
11th September.
Much obliged.
Item number 4.
My lord, this is a writ petition challenging the suspension of village council in Lai Autonomous District Council, my lord. And the suspension order is in page number 55 of my application, my lord. My writ petition, my lord.
55.
Yes, my lord.
What are the provisions here in respect of suspending the functioning of a village council?
My lord, if I may take my lord to page number 6 of my petition.
Page 6.
6, my lord.
Okay.
There's a section 10, section 10 of the Lai Autonomous Village Council Act 2010, my lord. wherein it says that, my lord, may I read out, my lord?
Yes.
The executive committee may appoint a commission consisting of not more than 3 persons from amongst the officers of the district council to inquire into the affairs of the village council. If it considers reasonable on a complaint in writing that the village council is too inefficient or is unable to carry on the village administration or is acting in a manner prejudicial to the interests of the state or the district council or is known to have been indulging in corrupt practices in the manner of village administration, my lord. That's a relevant point, my lord.
Where is that order of suspension?
Page number 55 of my writ petition, my lord.
55.
55. May I read out again, my lord?
Yes.
The local administration department of the Lai Autonomous District Council issued 2 so-cause notices to the Dumzautlang Village Council following 2 complaints regarding local administration received from the Dumzautlang YLA branch and Dumzautlang Village Council member. 2 responses to the so-cause notices were received from the Village Council President. However, as the Executive Committee of the Lai Autonomous District Council could not accept the explanations and because there appeared to be instances of corrupt practices as specified under the power to establish a commission in the Lai Autonomous District Council Village Council Act 2010, Chapter 2, Section 10, so and so. As inquiry commission was established via notification number, so and so, dated July 1st, 2026. Due to these circumstances and as required by the Lai Autonomous District Council Village Council Act 2010, the Executive Committee of the Lai Autonomous District Council hereby suspends the Village Council effective from the date of this notice. This suspension period shall remain in effect until the Inquiry Commission submits its report and a final decision is made. Furthermore, the Executive Committee of the Lai Autonomous District Council, exercising the powers conferred by the Lai Autonomous District Council, so and so, hereby appoints the following persons as caretaker to temporarily manage the Dumzautlang Village Council during this suspension period.
All right. Is there any appeal? Provision for an appeal?
No appeal, my lord.
All right.
The suspension period is only for 3 months, my lord.
So 3 months will expire on 9th.
Yes, 9th, it starts from 9th July, my lord.
Oh.
Plus
9th,
October, 9th
August,
October, my lord.
September, October.
Yes, my lord.
Heard learned counsel for the parties. The petitioner before this court is, you are the office bearers.
I'm the village council president, my lord.
Who? Number 1?
Number
or
1.
two? Number 1.
Yes, my lord.
2 and 3?
2 and 3 are the vice president and the treasurer, my lord.
Petitioner 1 is the president of the village council. Petitioners 2 and 3 are the vice president and treasurer respectively of the Lai Autonomous District Council.
Of the Dumzautlang Village Council, my lord.
Of the so-and-so village district, so-and-so village. Pursuant to certain complaints alleged to have been made by the residents or members of the village council against the petitioner, show cause notices were issued, to which the replies were duly filed with all relevant documents. However, notwithstanding the reply furnished, which the petitioner claims is a satisfactory reply to the notice issued by the concerned authority, the respondent authority proceeded to issue the impugned suspension order dated 9th of July, suspending the
Dumzautlang
The Executive Committee of the Lai Autonomous District Council hereby suspends the Dumzautlang Village Council effective from the date of the notice. The suspension period will remain in effect until the Inquiry Commission submits a report and the Executive of the Lai Autonomous District Council excising powers conferred under the Lai Autonomous District Council within bracket Village Councils bracket Close Act 2010. Appointed certain members to be the caretaker members to temporarily manage the Domzautlang Village Council during the suspension period. Para. It is submitted that the replies given to the show cause notice clearly substantiated, clearly answered the allegations made against the writ petitioner. There were no mismanagement as alleged. Notwithstanding that, the impugned order has been issued. Being agreed, the present writ petition has been filed. Para. Let notice issue, returnable 4 weeks. Anyone for the council? Respondent 1, 2, 3. Any government council?
My lord, we are for LADC council.
Mr. So-and-so appears for respondents 1, 2, and 3.
Yes, my lord.
Therefore, notices in respect of 1, 2, and 3 stands waived. However, steps on respondent 4, 5, 6, 7 be undertaken by speed post within 3 working days. Extra copies, if not already furnished, be furnished to the learned counsel appearing for respondents 1, 2, and 3. Relist after the returnable date.
My lord, if stay may be granted during the pendency of the writ petition, my lord. Stay of the suspension order, my lord.
Stay of the suspension will give you the ultimate relief you are asking for. We'll issue a notice on the interim prayer, making it returnable on 2nd of September. Can you get your instructions by then?
Yes, my lord. we'll
Not
seek
2nd, 1st of September.
Yes, my lord.
Yes?
Yes, my lord.
List the matter for consideration of interim prayer on 1st of September.
Post applies, my lord.
Item number 5.
May it please, Your Worship.
Yes.
The petitioners are, Your Worship, aggrieved by the non-payment of compensation to them under section 23(1)(a) and 23(2) of the LA Act 1894. In spite of the fact that their lands were acquired by award number 2 of 2008, and the compensation was also paid to them. But the collector had failed to award them compensation under 23(1)(a) and 23(2). In fact, there are a number of cases which have been decided by this Honorable Court regarding payment of solatium in interest. In fact, we have annexed one, which is one writ petition, which is at page 156, Your Worship. Annexure 8 of the writ petition. WPC 74 of 2019. The grievance of the petitioners in this WPC 74 of 2019 was also similar. The award was paid to them, but no award under 23(1)(a) and 23(2) was made by the collector. And the landowners in that writ petition had claimed the same by filing this writ petition. And, Your Worship, if I may take your lordship to the operative portion of the judgment at page 166, Your Worship.
Yes.
Para 13. In view of what has been discussed above, the writ petition is disposed with a direction to the district collector to make an assessment of solatium and interest to which each of the petitioners would be entitled to for acquisition of their land, which was covered by award number 5 of 2007, and to thereafter pass a concise and consolidated award on the entitlements of the petitioners. Respondents will be at liberty to verify identity of the petitioners vis-a-vis the beneficiaries of the award 5 of 2007. The entire exercise should be done as expeditiously as possible, in any case within the outer limit of 3 months from the date of receipt of a certified copy of this order. So, Your Worship, coordinated
You're
bench-
praying for similar orders.
Similar order, Your Worship. Similar relief is claimed. Even in our case, award 2 of 2008 was passed according the lands of the petitioners. Award was satisfied, but solatium interest was not awarded by the collector. So we're claiming that.
What do you say, respondents?
My lord, the present petitioner already approached this honorable court by filing WPC 74 of 2019. Then in the meantime, the award was passed in the year 2008. Now, after a lapse of 18 years, he's coming into to the court. That is not barred by limitation, my lord. Then in the meantime, in WPC 74 2019, the prayer of the petitioner has not been allowed. Then the right of the petition had already been gone, my lord.
What was the prayer?
Your Worship,
For solatium and interest.
Your Worship, this judgment my learned friend is referring to is at page 156, which I've just read the operative portion. Your Worship, in WPC 74 of 2019, that was filed by the petitioners for solatium in interest with regard to award number 5 of 2007. But inadvertently, the present petitioners were also included in the list of petitioners in that matter. Although that was a case for payment of solatium and interest with regard to award 5 of 2007. The instant petitioners were also included by mistake in that list of petitioners. But subsequently, after disposal of this writ petition, an IA was filed for deleting the names of the instant petitioners from the name of petitioners in WPC 74 of 2019. That IA has been also annexed, Your Worship, by us, which is at Annexure 11, page 170. There, Your Worship, the Honorable High Court has clarified that WPC 74 of 2019 deals with award 5 of 2007 only. And the application was dismissed because the application was for deleting the names of the instant petitioners from WPC 74 of 2019.
This is at, IA is at page 170.
Yes. If I may read this, Your Worship.
Oh.
I'll start from page 172.
And start from para
Para 2.
2 or 3, yes.
This interlocutory application has been filed by some of the writ petitioners in WPC 74 of 2019 with a prayer to that this court would allow the deletion of the names of the applicants from the list of petitioners in WPC 74 of 2019 and allow necessary modification in the cause title of the original writ petition. The writ petition was disposed of on 23/9/2025 with the following directions. That is, I'll go to para 4. Learned senior counsel appearing for the applicants has submitted that on a bona fide mistake on the part of the counsel who had drafted the writ petition, the names of the present applicants who were arraigned at serial number so-and-so and who were not involved in the litigation of award 5 of 2007 had been included as petitioner in the writ petition. It was on a bona fide mistake of the counsels that the names have been included in the present writ petition, although they were owners of land involved in another award, namely draft award 2 of 2008. Learned senior counsel has submitted that the names of the applicants are required to be deleted or shown as deleted from the list of petitioners in WPC 74 of 2019 disposed, so that their rights to pursue remedies in connection with draft award 2 of 2008 do not suffer in any manner. So, Your Worship, these are the submissions of the counsels for the respondents. I'll take Your Lordship to the operative portion.
Yes.
Page 175, para 12. In the present case, the applicants have not argued upon merits or directions on the claim made by the writ petitioners in WPC 74 2019. The applicants have not prayed for any change, modification, or correction in the order dated 23/9/2025 in WPC 74 2019. The limited prayer of the applicants is that since they were not involved in the litigation of award 5 of 2007, the order dated 23/9/2025 ought not to curtail their rights to pursue remedies in connection with draft award number 2 of 2008, wherein their land was involved. The reasons for approaching this court has been explained by the applicants to the effect that when the respondent authorities received the judgment order dated 23/9/2025, passed in WPC 74 of 2019, a process for seeking clarification has been initiated as to whether the assessment for payment of interest and solatium as directed by the court in the order under consideration should be restricted for beneficiaries of Award 5 of 2007 only. Apprehending that the implementation of the order dated 23/9/2025 may be delayed due to inclusion of the name of the applicants in the array of parties in WPC 74 of 2019, this interlocutory application has been filed. Agreeing with the law laid down by the Apex Court regarding maintainability of interlocutory applications or miscellaneous applications in disposed of matter, I am of the considered opinion that this interlocutory application is not maintainable in law and therefore is not entertained and dismissed. Moreover, modification of cause title of a writ petition cannot be allowed after a writ petition stands disposed of. However, in the interest of justice and to facilitate implementation of the orders passed in the writ petition, it is clarified that since this court in the order dated 23/9/2025 had required the respondents to make an assessment of solatium in interest to which the petitioners would be entitled for acquisition of the land which were covered by Award 5 of 2007, the respondents are required to take into account the Award 5 of 2007 and implement the judgment dated 23/9/2025 with regard to those petitioners in the writ petition who were litigants in Award 5 of 2007. So in that WPC 74 of 2019, the instant petitioners who are landowners whose lands were acquired in Award 2 of 2008 were mistakenly added as petitioners.
But your IA was not admitted.
It was not admitted.
Not allowed.
Yes. Our prayer was for deletion of our names from WPC 74 of 2019. But the Honorable High Court had clarified that the direction in 74 of 2019 will apply to landowners in 5 of 2007 award only. So now the landowners in award number 2 of 2008 are before your lordship praying for awarding solatium interest. There is no bar from the Honorable High Court that the instant writ petitioners cannot file a fresh writ petition claiming solatium interest in award 2 of 2008.
That was not answered.
Yeah,
That was not answered.
yeah.
The view of the court in para 15
Yes.
is that it reiterates what the earlier judgment had said,
It is meant only for landowners in 5 of 2000.
5 of 2007. Even otherwise, it would have been meant for the landowners.
Yes.
Because this case is not about you.
Yes.
LA dispute is not about the present petitioners.
Yes.
So even if the authorities wanted to implement it, they could not have because you are not a party to that. But will it give you a right to now come across? You should have filed a review. I'm not giving you legal advice, but
Our claim to solatium interest for award 2 of 2008 was never addressed by the High Court. In fact, we are claiming it now. That door is still open.
would you like to obtain instructions here? We can keep it for Monday, Tuesday.
Yes, my lord.
Get your instructions.
Yes. Yes, my lord.
And regarding the delay, Your Lordship, at page 166 in WPC 74 2019, we are-
166.
para 10. On the issue of the belated approach to this court for asserting rights accrued to the petitioners under the Land Acquisition Act 1894, learned senior counsel has relied upon case of Vidya Devi versus State of Himachal Pradesh and others, reported in 2022 SCC 569, where the Honorable Apex Court has held that when a citizen is divested of the right to property without being paid compensation, the cause of action is a continuing one. The Apex Court has observed that the demand for justice in such cases is so compelling that the delay, if any, in approaching the court should not act as a bar for the citizen, more so when the state admitted that the land has been taken over without following due procedure established by law and norms. So, Your Lordship,
Court Master, just a minute. Give us the Land Acquisition Act. This is under the old act.
yes, 1894.
Where are the relevant provisions?
23(1)(a) and 23(2). Solatium, and the 23(2) is solatium, I think, and 23(1) is 23(1)(a) is 12% interest. These are statutory benefits, Your Worship.
These are already awarded in your favor.
These were excluded in the award.
Oh.
That is why we are claiming these, Your Worship. These are statutory benefits, Your Worship. In fact, it is the duty of the collector to award these. Your Worship, under section 23(1)(a) deals with market value, 23(1)(a) is interest, 23 subclause 2 is solation. And all these components,
23(1)(a) and which is the other section?
23 subclause 2,
23 subclause 2,
30% solation.
30%.
Ashok, there are other cases also which have been disposed by the normal court, whereby directions were made to pay solation in interest. And in fact, even the writ appeals have been dismissed. I can lay those judgments before your Lordship.
You do it on the next day.
Yes, Your Worship.
We are just giving them
Yes.
an opportunity to complete their instructions.
Yes, Your
My Lord, if I may, one submission.
Yes.
The petitioner herein claim compensation under section 23(1)(a), 23(2), and 34. However, that should be calculated interest from market value of the land. However, if, my Lord, kindly see the award number 2 of 2028, there is no any market value on that.
In the order,
My Lord, page number, award number 2 of 2000. Okay, 10%. Page 104, next one. It just mentioned the total amount. There is no any market value of the land.
page number
104.
104.
Yes, my Lord.
You
Page
come to page 105, para 4, towards the end. The uniform rates by the DC. Have you found it? We have about 4 or 5 lines from the bottom. In para 4. Uniform rates fixed by the DC and district collector
However,
was properly examined in the context of prevailing market rates.
Your Worship, they have not challenged the award. It is not the case of the respondents that the award is illegal and no challenge to the award has been made. The award has already been satisfied. Now the question is only payment of solation and interest.
Heard Mr. A.R. Malhotra, Learned Counsel appearing on the petitioner. So Learned CGC is also
For
the state
respondent
government.
number 4.
CGC for respondent number 4
4.
and state government for
1 to 3.
1, 2, 3. Petitioners were landowners and the land was acquired under the Land Acquisition Act 1894. Compensation was duly calculated and awarded. However, the solution and interest under section 23A1,
1A
1A
and 23.
and 23(2) and 30 something you said?
34 interest, section 34.
34.
Interest for
Has-
delayed payment.
Interest for delayed payment has not been given to the petitioner, which the petitioner submits, counsel for the petitioner submits that they are entitled to as specified under the statute. The respondents are duty bound to make such payments. So, para, learned CGC has raised an objection to submit that the writ petitioners had earlier approached this court by filing WPC number
74 of
74 of
2019.
74 of
2019.
2019, which came to be dismissed.
No, Your Worship, which was allowed. The direction was for calculation of solution and interest with regard to award 5 of 2007.
Which was disposed of with a direction to the respondents to calculate the award, calculate the solution and interest in respect of
Award number 5 of 2007.
award number 5 of 2007. Stop. It is the submission of the learned counsel for the petitioner that the present writ petitioners, although were arrayed as writ petitioners in WPC 74 of 2019, they had no claims insofar as award number 5 of 2007 is concerned. Insofar as the present writ petitioners are concerned, their claim is in respect of award number
2 of 2008.
2 of 2008. Stop. Therefore, their names were wrongly arrayed in the said award, in the said writ petition. Stop. After disposal of the writ petition, the petitioners had filed an IA seeking deletion of their names by filing IA number so and so. Stop. This IA came to be disposed of. IA came to be disposed of by a coordinate bench. Stop. Although the prayers made in the IA in respect of modification of the course title of the writ petition 274 of 2019 came to be rejected, the coordinate bench reiterated the directions of the writ court that the solution and the interest are to be granted to the writ petitioners in respect of the land which is covered by award number 5 of 2007. Stop. It is therefore submitted that in a sense, the writ court never rejected the prayers of the writ petitioner, inasmuch as the direction was for calculation and release of the solution and interest only in respect of the award number 5 of 2007, and which award admittedly is not connected with the present writ petitioners. Stop. The land acquired by the respondents culminated in award number 7 of 2000,
2 of 2008.
2 of 2008.
8.
And the claim required to be made by the petitioners was not rejected or restricted by the writ court, either in the writ petition being WPC 74 of 2019 or by the subsequent IA, by the subsequent order dated so and so passed in the IA. Stop.
IF Civil 42 of 2016.
IA Civil 42 of
16. 2026, sorry.
2026. Stop. It is submitted by the learned counsel that where the statute imposes a responsibility on the respondents to award the solution and the interest in respect of the land acquired um, from the citizens, they are duty bound to implement the interest and the solatium has not been released. Stop. Therefore, notwithstanding the judgment of this court in WPC 74 or so and so, as also the rejection of the prayer in the writ petition for deletion of their names
In the IA, Your Worship.
from the array of the writ petitioners in WPC 74 or so and so, by way of IA number so and so, by which the prayers were rejected by the order dated so and so, passed by coordinate bench, in view of the specific provisions of the statute, and in the absence of any dispute that the compensation awarded to the writ petitioners in respect of the land acquired is by way of is connected to the award number 2 of 2008, and also in the award number 2 of 2008, which is available in the pleadings before the court, there is no order has been found for release of the solatium and the interest. Stop. Therefore, the claim of the writ petitioner for solatium and interest in terms of the LA Act of 1894 survives. Stop. The Learned Counsel for the petitioner has referred to judgment passed by the coordinate bench in WPC number so and so.
74 of 2019 itself.
Which judgment you're referring? Similar?
The same 74 of 2019, the operative portion.
The counsel for the petitioner therefore submits that the judgment and order passed by the court, it was by a division bench.
Your Worship, single bench.
Then what is this division bench order?
The division bench order is regarding reference which was made by the court, single bench, whether a writ petition can be filed for claiming solatium and interest.
Okay.
And the reference court had clarified that a writ petition lies for claiming solatium and interest.
So where is the order of the single judge?
Judge, it starts from page 156. Page 166, para 13 is the operative portion. Para 13.
We submitted that the coordinate bench of this court had earlier dealt with similar orders and had passed a judgment in favor of persons similarly situated in WPC number 74 of 2019. By the judgment and order dated. Sorry, what is the judgment?
Page 156, Your Worship.
126.
156.
156.
Order dated 23/9/2025. Operative portion is at para 13, page 166.
No, I'm referring to the judgment of that 74 of 19.
Yes.
This is the one.
Yes, 74 of 19.
Okay.
Operative portion is at para 13.
All right. By the court, by the coordinate bench, by the order dated 23/09/2025, passed in WPC 74 of 2019, it is submitted that this the claim of the petitioners are similarly placed like the petitioners in WPC 74 of 2019, and therefore the writ petition be allowed and suitable directions be issued. Considering the issues urged before the court, we permit the learned CGC as also the State Council to complete their instructions in the matter in respect of the orders passed by the court which are enclosed to the writ petition as to whether the case projected by the writ petitioner is similar to the case projected in WPC 74 of 2009, which came to be disposed of in the YD order dated 23/9/2025. On this limited point, the respondents will obtain their instructions and apprise the court on Monday, Tuesday, all right, 25th. Although notices are not issued, the petitioners will furnish extra copies to the learned State Council and the learned CGC. Release this matter again on 25th
I'm okay.
of August.
Item number 2.
You get hold of this book? Yeah. Yes.
So my lord wanted to see 2013 Act, my lord.
Yes.
Now, my lord, section 33 of the 2013 Act. My lord, section 33 allows for correction to awards, but only on certain circumstances, my lord. My lord has seen section 33.
Yes.
My lord, I'll read section 33. The collector may at any time, but not later than 6 months from the date of award or where he has been required under the provisions of this act to make a reference to the authority under section 64, before the making of such reference by order correct any clerical or arithmetical mistakes in either of the awards or errors arising therein, either on his own motion or on the application of any person interested or local authority, provided that no correction which is likely to affect prejudicially any person shall be made unless such person has been given a reasonable opportunity of making representation in the matter. The collector shall give immediate notice of any correction made in the award so corrected to all the persons interested. Where any excess amount is proved to have been paid, my lord, this is not relevant. So the
You are
first,
challenging notification.
yes, my lord. So what we are challenging, my lord, if your lordship will see,
They've changed
initially
the-
at page number 60, my lord,
They've changed the multiplication factor
correct, my lord. They changed the multiplication factor. Now, my lord, our humble submission
after
is
acquisition.
after the acquisition, after the award was made, after the award was finalized, and our humble submission, my lord, is that this is not a mere clerical error, my lord. It changes the substantive basis for compensation itself.
Page number 60.
My lord, page number 60 is the first corrigendum that was submitted, my lord. Now, this was before the award was finalized. So now we have no problem with this corrigendum, my lord. This is of 19 January 2026. Now, this was approved, my lord, via letter dated 4th February 2026 at page number 67, my lord. Page number 67 is the approval of this, my lord. Now, subsequent to this approval, my lord, a corrigendum was again submitted at page 71, my lord.
Yes.
Corrigendum was again submitted at page 71. Now, this is where the problem comes in, my lord. We are saying that since this award has already been finalized, corrigendum cannot be made for the subject matter that we are concerned with in this case, my lord.
All right. At this stage, we'll issue a notice.
Certainly, my lord.
Heard learned counsel for the petitioner. Petitioner is aggrieved by the alteration of the compensation awarded by the respondents. It is submitted that after the award was declared, by subsequent notification, the multiplication factors were altered, thereby altering the compensation payable to the writ petitioner. It is submitted that there is no provision under the statute for such alterations or corrections. Section 33, it is submitted that section 33 relates to only clerical errors to the awards passed by the collector. The learned counsel for the petitioner therefore submits that this alteration of the multiplication factor pursuant to the declaration of the award cannot be considered to be a clerical error.
Correct.
And therefore is not authorized under the provisions of the Act. Considering the submissions made, anything to submit?
As of now, Your Lordship, I would like to submit that the writ is liable to dismissed as the corrigendum was issued pursuant to the statutory power available to the competent authority and within the
You
prescribed.
should notice you file your response.
Yes, Your Lordship.
Learned, your MS,
Caroline Kelu, I believe.
Caroline, government advocate appearing for the respondents, accepts notice on behalf of all,
No, Your Lordship, 3 to 5.
3 to 5. 3 to 5. Where's CGC? MS so-and-so, CGC appears for respondent number 1
And 2, my lord.
and 2. Since the respondents are represented, notices are waived, the extra copies be furnished within a period of 1 week from today. The respondents are permitted to complete their instructions and they may file affidavit if so advised. Released after the returnable date.
Obliged, my lord.
Item number 6.
My lord, item number 6, I also appear for the petitioners, my lord. Now, in this case, my lord, we will have to withdraw, my lord. I pray for withdrawal with liberty to file afresh, my lord.
Counsel for the petitioner submits that on instructions that the writ petitioner seeks liberty to withdraw the writ petition and file it afresh. For what purpose?
My lord, because there are some documents which were not provided to us.
As certain corrections have been noticed pursuant to filing of the writ petition. Accordingly, any objections from the respondents? Government counsel appearing for the respondent does not object to be prayer made. Accordingly, writ petition stands dismissed on withdrawal with liberty.
Obliged, my lord.
For admission, item number 7.
Here, my lords, I'm seeking a short accommodation. My lords, it's right for admission hearing. The matter could, my lords, come up on Tuesday, my lords. There is just one short instruction I want to take from our client.
Mr. Jordan, counsel for the petitioner, submits that the matter be taken up on Tuesday, which is 25th of August. No objections are raised by the counsel for the respondent. Released again on 25th.
Obliged.
Item number 8.
May it please your Lordship. Lordship, I'm appearing on behalf of my senior, Mr. Caesaram Tsana, who cannot appear today due to some personal difficulty. May this matter kindly be taken up, Lordship, after a week.
All right. A prayer is made on behalf of Mr. C. Joram Channel and its senior counsel, who's leading the arguments on behalf of respondent 2.
Yes, my lord.
Respondent 2.
Respondent number 2 and
Yes, appellant.
Lordship, if this matter can be taken up on Tuesday, Lordship. The matter
They
has
want
been
it after a
pending.
week.
Matter has been pending for quite some time, Lordship. And moreover, this matter was already heard by Justice Kalita in the last 4 days. But however, there's some, with regards to the maintainability,
You are challenging what?
we're challenging the. We are challenging the judgment and order dated 29/2024, wherein the Learned Trial Court has acquitted the petitioner herein. But however, although being acquitted, Lordship, the cease article were not released to the petitioner.
You're praying for what?
We are praying for a modification, Lordship,
Only
of the
for-
order, specifically paragraph 48 of the order, the judgment and order.
Where is this order? 48. Seized articles are made absolute. That's the one.
Yes, Lordship.
What are the seized articles?
Seize article, seize money, Lordship. They have seized money from the petitioner.
All right, Tuesday?
okay, no problem.
Tuesday.
Yes, my lord.
Lordship, I've already talked to the senior counsel also this morning, and I don't think you have a problem.
I don't
taking
know,
up the-
there's a prayer, you sort it out, whatever date suits you. If Tuesday is all right with them, I have no problems.
Okay, Tuesday is fine, my lord.
Tuesday, matter be relisted again on Tuesday. On the request made by behalf of on the joint prayer of the council for the parties.
Obliged, my lord.
Item number 9.
Obliged.
Your Lordship, in this matter, I'll be filing my PORA for the sole respondent during the course of the day, my lord.
Mr.
Seetlan Thiang Lima.
Mr. So submits that he's been instructed to represent the respondent.
Sole
sole
respondent.
respondent, and he'll file, complete his instructions within a day or two. He therefore submits that the matter be listed after 2 weeks.
My lord.
Prayer made is not objected to by the counsel for the appellant. Relist this matter again after 2 weeks.
Obliged.
Item number 10.
Your Lordship, I am appearing on behalf of Miss Mary, who appears for the state respondents number 1 to 3.
Yeah.
If this matter may be listed after 2 weeks, since Miss Mary is on leave.
Okay. Any objections?
No, my lord.
It is submitted that the learned counsel representing the respondents, Ms. Mary L. Kyanti, is on leave, on medical leave.
Yes, Your Lordship.
And therefore, a prayer is made for deferring the matter for at least 2 weeks. Prayer made is not objected to, released after 2 weeks.
Obliged, my lord.
Item 11 and 12.
Yes, may it please Your Lordship, I am here for the respondent number 8 in item number 11 and petitioner in item number 12, Lordship. And in item number 11, we are seeking for another time to file the counter affidavit as we are not getting the definite instructions.
You are for respondent 11.
8 in
8.
item number 11.
Okay. Yes, petitioner?
Lordship, for the petitioner in item 11N, respondent number.
No, any objection to the prayer made by
No, Your Lordship.
learned counsel representing respondent number 8 renews a prayer for completion of instructions and filing an affidavit. He prays for 2 weeks. 2 weeks time. Prayer made is not objected to. Release this matter again after 2 weeks. Since item 12 is connected, both these matters we relisted again after 2 weeks.
And Lordship, in item number 12, there's an interim order. So the interim order passed.
Interim order, wherever passed, will continue. Matter be relisted again on 15 September.
No problem, Lordship. Obliged, my lord.
Item 13.
Those for the respondents, some counter affidavit was to be filed.
May I please, Your Lordship, here on behalf of my senior, Alan Hunsiama. My Lord, the notice has become infructuous, mainly because the VC members, they have resumed their seats, my Lord. So therefore, there's no point of proceeding with this petition, my Lord.
What do you say? It's become infructuous?
Yes.
Counsel, for the parties of the bar, submit that the challenge made in the present writ petition has become infructuous, as the writ petitioners have been reinstated.
My Lord, yes, the VC members, they have continued to be the VC members as normal.
The petitioners.
Yes, my Lord.
Petitioners are still continuing to be EC members.
Yes, my Lord.
VC members, village
Council members, my Lord.
Therefore, the claim made in the writ petition has become infructuous. Accordingly, it is submitted. The writ petition be closed, considering the prayer made and of the parties. The writ petition stands dismissed as infructuous. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
Much obliged.
Item 14.
Yes.
Lordship, as per the last court order, the registry was directed to track the postal consignment sent to respondent number 7, and as per the office notes, it seems that it has been delivered on 23/3/2026. And with regards to respondent number 3, fresh steps has been taken, but however, till date, there is no return of ID card.
Service report, in terms of the earlier order, fresh steps were taken on for respondent number 3. However, service report is awaited. Insofar as respondents number
7.
7,
7, yes. The registry has already tracked the consignment. And
no,
it
for
seems
which
in-
respondents?
Respondent number 7,
7.
yes. As per the office, the court's
Office,
order
as
dated
per office note dated 26/5, 2026, although ID card or service report has not been received. No, it says it has not been received.
Yes, Your Lordship, with regards to respondent number 3, ID card has not
No,
yet returned.
respondent 7. But there is no endorsement that,
Lordship, and after that, the matter was listed again on 29/5/2026. As per the court's order, the registry were directed to track the consignment.
but it is not done.
It has been done, Lordship, I've checked the office notes and there's a receipt. The green flag.
Is it in the second file? It is submitted that that in deference to the earlier order dated 29/5/2026, this court had directed that in so far as respondent 7 is concerned, since ID card or unserved notices have not been received back, therefore the office is to track the postal consignment and put a note by the next date. Respondent 7 is?
Respondent number 7 is the AIFF, All India Football Federation president.
Some president,
Yes, football, AIFF,
football.
football, yes.
However, from the office note, it is not clear whether the endorsements that the registry had indicated from the postal consignment that the item was delivered. No note is noticed in the office note. Registry will do the needful and matter be listed after 1 week.
Yes. Right, give you that.
Item 15.
This matter may kindly be taken up tomorrow. The conducting counsel, Mr. C. Dharmazawa, has been feeling unwell for the past 2-3 days and is now recovering.
You are sure he's going to be okay?
Yes, my lord. He
All
has
right, we hope so.
instructed
All
me-
right, tomorrow.
Right.
Matter be listed tomorrow on the request made by the council for the council appearing on behalf of Mr. C. Dharmazawa, senior counsel.
Right.
Item 16.
My lord, TCR has arrived. I think we'll have to prepare paper book at the expense of the appellant's matter.
As per the office note dated 18/8/2026, trial court records have been received. It is submitted that the paper book be prepared and the expenses to be submitted by the petitioner, by the appellant. Para. Registry will intimate the appellant regarding the costs to be deposited for preparation of the paper book, whereupon the cost being deposited, the paper book should be prepared. Released after 4 weeks.
Item 17.
That IA. That IA.
That I,
Yes.
I'm for the applicant, yes, on behalf of Jonathan Larin Plonga, conducting counsel.
All right. Anything more to submit?
No, madam.
Third counsel for the parties, this IA has been filed by the appellant as the applicant seeking condonation of a delay of how much? 102 days.
Yes.
102 days in filing the accompanying appeal. Stop. Notice in the matter was issued on so and so date. The opposite parties have filed their objections opposing the claims made by the applicant/appellant. Stop. Learned counsel for the appellant submits that the delay has been sufficiently explained. It was beyond the control of the appellant and for reasons which cannot be attributed to the appellant, and therefore the delay of 102 days be condoned and the appeal be admitted. Stop. Better. Per contra, learned senior counsel appearing for the respondents strongly objects to the submissions made. It is submitted that while the condonation of delay in a given facts and circumstances of the case, a court may take a liberal view. However, that would be dependent on the sufficient causes that may be shown by the applicant. Stop. Referring to the IA file, the learned counsel submits that there is no proper explanation for the delay that had occurred, let alone sufficient cause being shown for the delay that had occurred in filing the IA. Stop. Learned counsel for the respondent has referred to the following judgments in support of his contentions. Referring to the judgments, the learned counsel submits that where the explanation where the explanation is not sufficient, then condonation of a delay in filing the accompanying appeal, the prayer for condonation in filing an appeal should be rejected. Stop. From the pleadings filed before the court, it is submitted that the petitioner was not diligent and his bona fides are not clear on the grounds which are on the explanation furnished by the applicant appellant in support of his contentions that the delay be condoned. Learned counsel for the parties have been heard. Pleadings available on record have been perused. The grounds which are urged in support of the prayer for condonation of delay are enumerated in para 3 of the IA, which are extracted for convenience, extracted below for convenience. Extract para 3 entirety. Stop. Para. Having perused the grounds urged as also the objections filed, it is necessary to refer to Section 5, the Limitation Act. Para Section 5 reads as under. Stop. Careful reading of the section reveals that there is a discretion in the appellate court to condone a delay that may have occurred in filing an appeal which could not be filed within the period of limitation prescribed. Stop. However, this condonation has to be made on the explanation which the court will have to consider to be sufficient ground explaining the delay in support of the prayer made for condonation of delay. Para. Reading the grounds urged, it is seen that the first ground undertaken by the petitioner is that the judgment was pronounced on 22/11/2024, whereas the final decree was drawn only on 13/1/2025. Stop. Although not specifically, although not, no clear submissions are made, from a perusal of the grounds urged, it appears that the petitioner had put up a case that the limitation would not start from the date of delivery of the judgment, as the final decree was drawn only on 13/1/2005. In this context, a reference is required to be made to the provisions of Order 41, Rule 3, capital A. The statute itself provides for filing of an appeal from the date of delivery of the judgment and not from the delivery of drawing up of the decree. Stop. This interpretation of the court, this view of the court, is supported by a judgment rendered by this court as also by the Supreme Courts in this regard. Stop. The relevant extract of the judgments, relevant paragraphs of the judgments are extracted below. Para. Considering the findings of the court in these judgments, it is clear that the statute itself provides for filing of an appeal from the date the judgment is rendered, even if the decree may not have been drawn up or available immediately thereafter. Stop. Therefore, this first ground urged by the petitioner that the judgment was pronounced on 22/11/24 and the decree was drawn up on 13/1/2025 will have no relevance and will not lend any support to the contention sought to be raised by the petitioner that the delay, that the appeal could not have been filed without the decree being drawn up. Stop. There is no explanation seen in the IA that which shows that immediately after the delivery of the judgment, the applicant had taken steps to pursue the appeal. Stop. During the course of the arguments on a pointed query made by the court to the counsel for the appellant as to whether as to the knowledge of the delivery of the judgment by the applicant, it was stated that the applicant is one of the legal heirs substituted for the original defendant number 3. Stop. It is also admitted that the defendant number 3, their mother, the mother of the applicant, expired during the trial, during the pendency of the trial. Stop. Therefore, it is clearly admitted, or at least not disputed, that the petitioner was aware of the process of substitution by petitioner, applicant, process of substitution in place of the original defendant number 3, who was her mother, who was his mother, as also to the date of delivery of the judgment on 22/11/2024. Stop. The explanation sought to be made reveals that there are, although some dates are indicated, the there are no specific explanations as to why, as to how the delay had occurred pursuant to the delivery of the judgment by the trial court. For instance, in para 3.1, it is stated that the applicant, after delivery of the judgment, the applicant required some time to understand the contents and consequences of the judgment. However, no dates are specified as to how much time was required by the applicant. Stop. Again, it is stated that the applicant took steps to approach the legal counsel for further action. However, no specific dates are referred as to when the applicant approached the counsel to take steps or to obtain legal opinion as to whether appeal is to be preferred. Stop. In the said paragraph, it is stated that the petitioner had approached several legal counsels from 17 to 2025 to find a suitable counsel. Stop. But none of the counsels he had contacted were practicing in the High Court. Stop. What is the limitation, Mr. Counsel?
90 days, my lord.
90?
90.
So, it ought to have been filed in by about 24th of February, end of February.
My lord.
However, from the date of delivery of the judgment, that is 22/11/2024, or from the date of drawing up of the decree, which is 13/1/2025, till 17/2/2025, there is no explanation by the applicant as to how, as to the steps taken by the applicant, as to what steps were taken by the applicant. Stop. At para 3.2, it was stated that the petitioner got in touch with the present counsel sometime in the end of February, but thereafter he was preoccupied with his marriage, which took place on 6th of March, and therefore the appeal was inadvertently delayed due to the counsel's limited availability in the lead up to and after math of the wedding. Wedding of whom? The counsel or the applicant?
Counsel.
Council must be.
Counsel?
Yes, Jonathan.
Okay. The wedding of the counsel. One row. Yeah. There is no explanation as to whether any communications were issued to the counsel, as none had been enclosed to the application. Again, in para 3.3, it is stated that in April 2025, the council was out for professional duties and thereafter the court remained closed for Good Friday and Easter holidays. Stop. However, no specific dates are specified. It is also stated that the council faced personal and medical problems in the month of April and May, and therefore no effective steps could be taken during this period. Stop. It is only towards the end of May that the petitioner obtained copies of the judgment, decree, evidence, plaint, etc. And thereafter, two certified copies were obtained on 23/6/2025, which came to be issued on 4/7/2025. Stop. It is stated at para 3.5 that the court vacations had started from 7/11/25 and the council for the applicant had remained on vacation from 3/7/25 and returned on 11/7/25. Stop. Thereafter, on 14/7/25, upon resumption of the court, the preparation of appeal had started, which was finally completed on 21/7/25. And stop. There is no averment as to when the appeal was filed. Stop. From the endorsements by the filing section, it is seen that the appeal ultimately, the IA was filed on 24th of July 2025. Stop. Reading these explanations, the question which is posed before the court is whether under the provisions of Section 5 of the Limitation Act, whether it is a good cause within quotes or sufficient cause which is required to be explained by the litigant in order to obtain, in order that the court may pass appropriate orders condoning the delay. In this context, the reference of the judgment of the apex court rendered in so-and-so versus so-and-so is necessary, is very pertinent, as the court had explained the distinction between a good cause within courts and sufficient cause. Stop. The paragraphs relevant are extracted below. Further, a coordinate bench of this court, coordinate benches of this court had also held that mere explanation without any supporting documents may not be sufficient to indulge the discretion of the court for seeking prayer for condonation of the delay. So, these judgments require a mention at this stage, and the same are referred to as under. While it is not in dispute that ordinarily prayer for condonation of delay, the court has to take a liberal view. Stop. However, in matters relating to civil disputes, once a judgment and a decree is delivered by the trial court after examination of detailed evidences, proper evidence is adduced, and the judgment, the rights qua the parties, QUA, have been settled by the court, more particularly in a matter which is decided intra-party and not ex-party. Stop. Where there is a responsibility of the state or an agency of the state under Article 12 of the Constitution of India for undertaking their duties prescribed under a statute, there are instances where courts have taken a liberal view, with some explanation being furnished by the litigant, which are considered sufficient for condonation of the delay. Stop. However, in respect of civil disputes and personal rights, where personal rights are being decided by the trial courts, what must be seen is the bona fides of the applicant, the due diligence, the manner in which whether the applicant was diligent in pursuing the matter, and whether the causes on a plain reading which are placed before the court reveal certain causes which are completely beyond the control of the petition of the applicant, and thereby causing delay, and thereby the appeal against the said judgment, order, and the decree could not be filed within the period of limitation prescribed by the statute. Stop. Para. In the facts of the present case, it is a question of a dispute between the applicant and the opposite party, which was decided by the district judge, Kolasib. Which district?
Aizawl district, my lord.
Aizawl.
Senior civil judge, my lord.
Senior division, civil judge, senior division 1, Aizawl judicial district. In respect of a claim of land covered by LSC number, what is the LSC number? 104302/01/458 of 2008.
Yes, my lord.
Is that the correct one?
Yes, my lord.
And the civil judge had clearly held that the opposite party is a legal and bona fide owner of the land covered by so and so so and so. Stop. While it is open to the applicant to agitate the matter before an appellate forum as prescribed under the statute on the grounds and reasons undertaken in the appeal memo, the fact remains that the appeal cannot be entertained unless the delay as specified by under the Limitation Act is condoned. Stop. Para. The discussions aforementioned would clearly reveal that while a liberal view is required to be taken ordinarily, however, there is a bounden duty on the applicant to diligently explain and urge before the court the sufficient cause within courts, which would invite the court's discretion for condonation of the delay as prayed for. Stop. The law laid down by the apex court distinguishing good cause within courts and sufficient cause clearly adumbrates the principles as to what would be considered to be a sufficient cause as specified under Section 5 of the Limitation Act in order to enable the court to allow the prayer for condonation of the delay. Stop. Para. Considering the facts urged before the court and the explanation sought to be put up by the applicant. It is the considered view of the court that the explanation explanation put up by the applicant cannot be considered to be sufficient cause. The explanation put up by the applicant may be good cause for a delay, but certainly not sufficient cause. Considering all of the above, this court is of the view that the applicant has failed to satisfy the court that the delay, that there was sufficient cause for which the delay had occurred and for which the applicant, which were beyond the control of the applicant. The prayer made in the IA therefore stands rejected. IA stands dismissed. Consequently, the accompanying appeal is also dismissed. No order is proposed.
Item 18.
There is 17, right?
May I please, Your Lordship?
Yes.
Yes, my Lord, we have filed this IA regarding that the release of 50% of compensation amount, which was already deposited to the fast track court, come additional district and session judge scholarship, as directed by this honorable court on 28/10/2025. And the state respondent deposited that amount on 10/11/2025 to the fast track court. So, my Lord, our main prayer is to release this 50% without security, or at least with security, to the landowners.
What security are you providing? Bank guarantee?
Undertaking, my Lord. Personal undertaking or guarantee?
Undertaking is not a security. It's an undertaking. Supposing tomorrow your petition gets dismissed, then you have to refund the amount. What is the guarantee?
My Lord, since that we never received any single penny regarding this.
We understand.
Yes, my Lord.
Court has directed them to deposit. Where is that order of directing them to deposit?
Page number 54, my Lord. Our petition IA 24. Page number 54.
What is the date of the order?
28/10/2025. 28/10/2025 is the date of the order.
Page number?
54.
54.
Para number 11 and 11.1 is the operative part, my Lord.
You're the government counsel. Who's for the government? Who's filed the IA? You have filed the IA.
Yes, filed the IA.
IA is filed by the state.
IA is filed by the landowners, the degree holders. Now I have filed appeal petition on behalf of the state as a private counsel, and the government advocate has submitted a written objection to the IA filed by the landowners. My Lord, in this case, if I may, with your Lordship permission, in the last court date, my learned friend and I were both present, wherein this honorable court was of the opinion that supposing if we allow the deposit amount to be taken by you, and it would mean that we would dispose the case. Then my learned friend was asked on that day whether he is willing to provide any security, just as your Lordship has asked today. But since, with the consent of my learned friend, this case has been posted again today for hearing on the main appeal. Now, I would like to make a prayer in this case. My Lord, there is an a connected case. We have filed land acquisition appeal against the original judgment and order, by which the impugned attachment order and the judgment and order in execution case was challenged before this court. Now this RFA is for challenging the order of attachment and the judgment and order passed by the executing court.
Is it not listed today?
It is listed today, that RFA. Now the LA appeal is pending for consideration, my lord. So my request is that LA appeal and this RFA may be taken up together, because I believe my learned friend would also represent the respondents, the landowners in that LA appeal. In this bunch of petition, coast list number 18 to 22, they are the same council.
Okay.
So if I may make a prayer that with regard to item number 18, RFA 49 is connected with LA appeal number 6 of 2025. All these LA appeals may be taken up together with this RFA, so that there would be no miscarriage of justice. If this LA appeal is disposed, and my learned friend may have the opportunity to withdraw the money if he wins the case,
Yes.
I think that would prevent miscarriage of justice, my lord.
What do you say?
In fact, I had requested him last night also.
My lord, but the main judgment and award was not stayed. And since, if it possible, my humble prayer is that if it can be taken up on a fixed date and as soon as possible, that is my humble prayer, my lord.
You give a date when you want it.
3rd September, my lord.
3rd September.
3rd September.
Counsel for the parties are agreed that these bunch of cases be listed as a fixed item on 3rd September.
My lord, along with the fixed LA appeal, along with the connected LA appeal, I'll just...
You have the numbers?
Yes, my lord. In respect of...
No. This, presently, this item number 18.
Yes, I'll mention that, my lord.
Item 18 is connected with which item?
Item 18 is connected with LA appeal number 6 of 2025. It is not listed today, but it's connected with LA appeal number 6 of 2025.
And what about the other items?
Yes, I'll mention that, my lord. Item number 19 is connected with LA appeal number 7 of 2025. Item number 20 is connected with LA appeal number 5 of 2025. Item number 21 is connected with LA appeal number 4 of 2025. Item number 22 is connected with LA appeal number 8 of 2025.
All right. We direct listing of the cases along with the LA appeal, Mr. Counsel? All right, heard counsel for the parties. It is agreed at the bar that these bunch of cases be listed again on 3rd of September, along with the respective LA appeals, particulars of which are mentioned below. All right? You give the list
Yes, my lord.
to the court master.
I'm obliged.
Obliged, my lord.
Item number 19.
Item 19 is gone along with all these matters. 19 to 22.
25.
Item number 23 and 24.
Yes. Did you get your instructions?
My lords, I believe
He's not here.
he's just coming, my lords, the learned counsel. Can be passed over, my lords.
All right, we'll call up after a while. Call up that supply list is there.
Supplementary list, item number 25.
May I please, Lordship? My Lord, in a judgment and decree, we have been directed to pay sum of rupees 13 lakhs on account of, my Lord, lapse on the part of the defendant, saying that because of the, my Lord, some natural calamity, the accidental which has been caused damaged the vehicles, and hence we
You are
have been
filing an
directed
IA for seeking condonation.
yes, I am coming. Yes, my Lord. There are two prayer. One is condonation, one is stay, my Lord. The thing is that, my Lord, just show me before Lordship that this is a fit case where, my Lord, pass an order for staying of the execution case, my Lord. Today is the date fixed for execution. Now, Lordship, thing is that the pendency of the condonation petition is not a bar under the law in terms of the order 41 rule 3. Therefore, Lordship, just want to show only prima facie case for a moment, my Lord. Page 25 for a moment of my appeal memo.
25 of?
My Lord, appeal. Memo of appeal.
Memo of appeal is not even numbered.
Yes, my Lord, but just want to show prima facie case, my Lord, that
What
it
prima
deserves.
facie? You have to first get the delay condoned before the appeal has to be
Absolutely,
heard.
my Lord, I would like to show one judgment, my Lord, where it is clearly stated, division bench judgment, where, my Lord, the pendency of the, my Lord, appeal, pendency of the condonation petition, not a bar to, my Lord, provide the interim protection. Reason is that, my Lord, so far the issue is concerned, my Lord, it is, my Lord, only directive, not mandatory. One judgment, my Lord, only one judgment. My Lord.
Appeal.
My junior,
Give us the appeal.
my junior will supply the, my Lord, judgment copy. Like this, my Lord, appeal memo, my Lord.
Yes.
Page 25, my Lord.
25.
My Lord, it is the 25, my Lord. Page 25. My Lord, kindly see that, my Lord, it is the inspection report which is the ultimate base of, my Lord, claiming compensation. Now, Lordship, kindly see column C, the 6th number, insurance certificate 15/4/2022 expired. And Lordship, kindly see the downside remark E. It seemed that the vehicle was hit by sliding stone while the vehicle was running towards the so-and-so, Aizol road and under construction. And D is, my Lord, containing driver cabin totally damaged, the vehicle chassis and body also distorted. Now, Lordship, kindly see, once this vehicle was not insured, my Lord, it is settled position of in case of claiming compensation arising out of the vehicle, my Lord, then my Lord, MSCT case is there under section 166. Because the person know that his vehicle is not insured and he is not allowed to fly on the road. Therefore, my Lord, he filed instead of my Lord, MSCT case, file a civil suit. Apart from, Lordship, kindly see.
What is the judgment passed?
My judgment passed in content page, my Lord, 46, where we have been directed to pay a sum of which 13 lakhs today, my Lord. Page 46, my Lord. There is no reason, my Lord, not a single word, my Lord, that on what basis the assessment was made up.
46.
Page 46. Yes, ma'am. Entire amount was given. And no reasoning, madam. Page 46, paragraph 23, 24.
There is no 46 in your appeal memo.
My Lord, the last part of the body before order, my Lord, if suppose pagination, my Lord, might be. Last
appeal.
Paragraph 23, 24, my Lord.
My Lord, may I? There has been a correction made in the petition.
Sorry,
in the filing. So the relevant portion of the judgment and order is on page Roman number 13, front page.
Sorry, ma'am.
Paragraph
Relevant
23 and
paragraph
24.
23, 24.
No, Roman 13 where?
In the front
No,
page.
my Lord, the
Judgment.
We are unable to find it.
No, my Lord, the judgment paragraph 23, 24, my Lord. Impugned judgment paragraph 23, 24, last part.
Okay,
before order.
23, 24, okay. Yes.
My Lord, kindly see paragraph 24 speaks about, therefore determining just and reasonable amount for compensation, this court takes consultation of the prices of the issue vehicle in India, which currently ranges from 12 lakh to 40 lakhs as well, and the price of the plaintiff vehicle quoted price is 70 lakhs. Order, in view of the above, the defendant directed to pay 13 lakhs. My Lord, on what basis, ma'am? There is not a single reasoning, my Lord. Even the inspection report says that only chassis was, my Lord, damaged, but entire cost of the vehicle was given, and what basis, my Lord? Quantum. Therefore, my Lord, there
What is
three
the
grounds,
stage?
my Lord.
What is the stage of the execution case?
My lord, today is the date for execution to pay amount, so my lord, that's why a little bit.
You
No, Lordship,
you file your objection, you go and appeal, why?
no, my lord, we have taken a step, but Lordship, may I show only one judgment, my lord. My brother will place before Lordship. Just paragraph 30 for a moment. My lord, there is no any bar, my lord. The division bench judgment of paragraph 30. Paragraph 30, my lord, fifth line. Conclusion part. Last part. Paragraph 30, conclusion part, line 5th, my lord. Order 41 Rule 3A was enacted not for purpose of prohibiting the stay of execution of decree pending consideration of the application for condonation. Now, Lordship, Roman 2, the word shall employed in Order 41 Rule 3A is permissive and not mandatory. Now, Lordship, another view that has been adopted that contained in my lord paragraph 32. Next page.
You first tell us what you are reading from this 30. You are reading only one line from somewhere 30.
My lord, thing is that, my lord, it shows that pendency of the condonation petition is not a bar to, my lord, provide protection for execution, my lord.
Who's for the respondent?
My lord, the notice will go, my lord.
Heard counsel for the parties issue notice on the condonation petition, seeking a condonation for a delay of how many days?
275 days, man.
275.
Well,
277, correction has been made.
277 as that had occurred in filing the accompanying appeal against the judgment. A judgment dated 12/8/2025, passed in civil suit number 13 of 2022. Stop. It is the submission of the counsel to the petitioner that by the said judgment, there was a direction by the civil judge senior division to the present applicants who are defendants in the said civil suit to pay an amount of rupees 13 lakhs within a period of 3 months from the date of this order. Stop. It is the submission of the counsel to the petitioner that the vehicle which was stated to be damaged belonging to the plaintiff was not for the reasons which can be attributable to the defendant applicant. Stop. In any view of the matter, the vehicle was not insured. Stop. The finding of the trial judge directing the defendants to pay the amount of 13 lakhs is not based any reasoning. Stop. In that view of the matter, it is submitted that during the pendency of the application seeking condonation of delay, the effect of the judgment we stayed. Having heard counsel for the parties, and upon perusal of the judgment passed by the civil judge senior division, it is provided till the next returnable date, the status quo be maintained as on today between the parties.
Well, we will take the steps, my lord.
The applicants will take appropriate steps before this court on the respondents, on the opposite parties. Matter is directed to be listed on 15th of September.
Well, much of it.
Obliging.
Item number 23 and 24.
Lordship, last order, day before, yesterday you passed order. So, my lord, so to release the matter today at Para, meanwhile, the learned counsels for Mizoram Public Service Commissioner will obtain instruction as to whether the petitioner can be shown tabulation sheet of first evaluator, second evaluator, also scrutinizer, insofar as the marks obtained by the writ petitions only. My Lord, so the Commission, first of all, I really appreciate your kindness to have instruction, to get instruction first. My Lord, at that day itself, I gone there, I met them, we had meeting. My Lord, actually the Commission, here the problem is that cannot show that the tabular form to the petitioners on the grounds that two reasons. One is that, Your Lordship, the petitioners are very reputed faculties working in reputed centers here, that centers in Aizawl, one is in Kate and one is in MS Academy, but if that was shown, because in Mizoram it is small size, so the names they will see are expat, they will see are expat, because we have only one university here, most of them from our universities, and our expat, even the signatures also, so that will breach the confidentiality of the Commission. So they'll be able to see their names, their signatures, everything. That is one reason.
We'll show it to the council. How will the council know?
Well, my Lord, actually, yeah, two reasons is that, my Lord, it would lead a bad precedent in the future also. Whenever these things, they'll come and they'll ask the court to see the petitioner. My Lord, I have one suggestion. The concerned persons have brought the two papers that their answer sheets, the tabular, everything. So, my Lord, just only we can see with you also in your room, just it will take only 5 minutes.
Why should I see it?
My Lord,
we'll give it to they are the ones who are before the court.
That, my Lord, even
you show it to the council. We'll modify this order. We'll say that not the petitioner, but the counsel for the petitioner.
That
only.
Actually, names are also theirs.
You don't trust your friend across.
I trust it, my Lord. That is no problem.
I don't think I'm a friend, my lords.
No, I trust. That only tabulation.
In the bar, you're of course adversaries before the court, but.
My Lord, the order is that writ petitioners.
We'll modify that. We'll say that the council, since the records are here before the court.
Yes.
The council will be permitted.
Yeah, it will be only 5 minutes. That only.
5 minutes, 10 minutes, you take whatever time.
Yes.
It's nearing 1 o'clock. You treat your friend with good coffee and you sit down and examine it.
My lords, I have just one submission. Inquiry was conducted. Your lordship saw the report. Inquiry officer himself says that these discrepancies are not only with regard to the papers of the petitioners, but with regard to the top 50, which he had evaluated. Now, my lords, it seems to be clearly a widespread anomaly which has happened in this case. And
what is the prayer that you are seeking from the court?
This is not PIL, Your Lordship.
My lords, it doesn't have to be a PIL.
No, what is your prayer now?
My lords, our prayer is, my lords, if your lordships, from the record, it seems that there is certain discrepancies which seem to be widespread from the inquiry report which they themselves rely on. So, my lords, since there is this fact which needs to be kind of verified, let, my lords, a court monitored commission be, my lords,
for what purpose?
To look into it.
What purpose will it serve now?
Because, my lords, if the discrepancies goes to the root of
the
yes.
If we, just a passing thought, if we order such a committee to examine, why not the subsequent examinations also, including the ones that by which you are selected? Everything will have to be reopened, selected.
We had come.
Vacancy of the quarter will be disturbed. All of the recruitments.
We are asking. We are giving you this liberty only to understand what is the prayer you won from the court now that you are already appointed by a subsequent selection process.
My lords, yes. My lords, if I may answer that. My lords, a subsequent selection of subsequent years is a different list altogether. Not a list, nothing has brought forth before this court. We have, please don't interrupt. We have come before your lordships with a very specific plea that, my lords, since there are these discrepancies, unprecedented case of use of whitener, Where, my lords, if you alter...
No, we are rephrasing it.
Yes,
The earlier allegations today,
yes,
in the face of the fact that, as I've repeatedly said, that is not a PIL.
yes.
You were aggrieved because you appeared, you did not get selected.
Because of, yes.
Because of whatever allegations. Hypothetically, if you had appeared and you had been selected, perhaps even with the use of whiteners, this way, that way, you may not have been aggrieved because you are selected.
We wouldn't have examined our papers. You're
No,
right,
no.
Your Lordship.
You would not have had any grievances.
Yes.
The fact that you are not selected, you have now come before the court. During the pendency, there were subsequent examinations where you appeared, you were selected, and now you are appointed in the posts which you want.
Yes.
The only grievance, perhaps, according to you, is that had you been appointed in the first selection, you would have claimed your seniority with effect from the date the others are appointed.
Your Lordship is right.
That's the only
My
issue.
lord, in that one, just to assist the court, that the subsequent examination that was filled on the basis of now vacant seat, depending on the vacant seat already filled in 2023.
If the commission
In
is
fact,
willing to
no,
adjust us in the...
in fact, my lord, they are not in the panel list also.
No, they can't adjust you because you don't belong to the cadre. You are not a part, you are not born into the cadre.
Yes, my lords, because of the discrepancy which we brought before your Lordships. This is the only issue. Your Lordships is, I understand what is falling from your Lordships. But my Lords, it's not that we have come with an empty, my Lords, case.
You examine it, and let us
My
know
lord-
if there is
my
any
lord,
discrepancy.
They are not in the panel list also. There are many panelists.
How
They
can
are,
we be, you've altered
We
our
are modifying this order, permitting the council on behalf of the petitioners to examine
actually,
your...
my humble prayer is just to dismiss since there is nothing to
All right, that we'll consider it. In deference to the earlier order dated so and so, the learned standing counsel for the MPSC submits that since the tabulators and the scrutinizers are also experts within the state of Mizoram, more particularly Aizawl,
Yes, Lordship.
and the writ petitioners are also from Aizawl, there is a possibility that the identity of the elevators, first and second elevator and the scrutinizer could be revealed to the writ petitioners if they are permitted to examine the tabulation seats as directed by the court. The learned counsel for the MPSC submits that this may lead to a precedent in the future as to that in similar cases.
It could breach confidentiality of the commission.
Every petitioner would now demand examination of answer sheets or scrutiny, which is otherwise not permitted under the rules.
There are no rules, my Lords, as such. There are no rules.
There are no rules.
My lord, we have instruction.
They have rules, but they don't have with regard to scrutiny
My lord,
and
that-
so forth.
With regard to the, what instructions you have?
My lord, that we have highlighted also, that,
No, are they by way publishing by
no,
way
no,
of-
actually that is confidential. That's it.
Confidential.
Yes.
As per the practice adopted by the MPSC. Stop. But on the consideration of the submissions of the learned counsel for the respondent, it is seen and the apprehension expressed by the learned counsel for MPSC, since the records are already in respect of the writ petitioners containing the tabulation sheets only.
Yeah. We have everything, Lordship.
Answer
But,
sheets.
answer sheet, but that, as per the last order, that is tabulation only.
All right. The records are available in court. We permit the same to be examined by the learned counsel, Mr. Jordan, representing the writ petitioners, in the presence of the learned standing counsel, as also the official.
Can we reflect the name and his designation?
Mr. Mr. So-and-so, Deputy Controller of Examination, MPSC. Stop. The records will be examined by Mr. Jordan on behalf of the writ petitioners. In court,
In court, my lords, the presence of the state AG may also, my lords, if he may also be part of it.
you want AG also?
Yes, my
You
lords.
want AG's protection? Right, the learned additional AG, who is also present in court, would also be, will also form a part, will also be present at the time of the examination by the counsel. Stop. It is made clear that this order will not be treated to be a precedent. For further orders, released again.
Lords, 2nd of September, 1st of September. 1st is Tuesday.
On 1st of September.
Yes. Extremely grateful.
My lord, can we have on second?
Second is a DB day.
If I may, my lord, the 1st of September I'll be out of station, my lord. So,
You will be out of station.
yes, my lord, I will not be available, my lord.
When can we have on 27 August? I also will be.
My lords, I have just a small issue.
You have it in the, on 3rd or 7th or whatever
Yes,
date you
my
want.
lords.
7th.
7th?
7th is Monday. My lords,
7th of September.
My lord, actually, I will not be. Can we have on 27 in lordship?
my lords.
My,
next
that's
week
a very
there's
small issue now.
I have an issue because I'm appearing in another district, my lords.
Then 8th, give us a date.
Somewhere, anytime in September.
8, 9, 10, 11, whatever date you want, you take
My
it.
lords.
My lord,
List it on so and so date.
My
You
lord,
give the agreed date to the court master.
all right. My lord, I have exam on that 5th, first week of September at Delhi. That's right.
Exam.
Yes.
You're sitting for an exam.
No, actually, that is different exam. Like, you know.
It's 31st, then 31st is August. My learned friend wants.
Yes, that is fine. I already booked my ticket on 4th of September. Then 31st is very fine, lordship.
Monday.
No, 31st, all right.
31st August.
31st of August. Okay.
Part 2 hearing list. Any councillors present? Item number 1.
Yes.
I'm having item number 15, my lord. This is a POCSO matter, my lord. Conviction under section 6 of POCSO, my lord. The respondent number 2, my lord, amicus curiae has not been provided yet, my lord. Since
Oh.
it's a POCSO matter, the informant or the victim, my lord,